Ever worried if your workplace is actually following their own rules?
Yeah, it's a thought that crosses everyone's mind from time to time.
Especially with things like disciplinary action.
Right, like are they really doing things by the book?
It's a big deal, and it can feel pretty scary if you think they're not.
Absolutely.
Well, today we're diving into a case that went all the way to the High Court of Australia, Elisha versus Vision Australia.
Oh, this one's fascinating.
Yeah, it really could change how we think about employee rights here in Australia.
No kidding, this case has some serious implications for workplaces all over the country.
So, to get us started, what exactly was this case about?
So basically, an employee, a Mr. Elisha, was let go from Vision Australia.
Fired.
Yeah, dismissed after a disciplinary process that, well, wasn't exactly by the book.
So not just your average unfair dismissal case.
Not at all. This one went to the highest court in the land, the High Court.
That's a big deal.
Huge. And what makes it even more interesting is that Mr. Elisha was awarded damages for psychiatric injury.
Really. Because of how his dismissal was handled.
That's right. The court basically recognized how much of an impact a breach of contract can have on an employee's mental well-being.
So we're talking unfair dismissal and mental health, all wrapped up in this one case.
Exactly. It's a complex situation with a lot of layers.
And to help us unpack it all, we've got Tim Donaghy's paper with us today.
Right. Contract damages and other compensation, what has changed.
Perfect. Today we'll break down the Elisha case, the High Court's judgment, and what it all means for you as an employee in Australia.
Let's do it.
Sounds good. So first things first, who is Mr. Elisha and what was his role at Vision Australia?
So Mr. Elisha worked for Vision Australia. They're a nonprofit that provides services to people who are blind or have low vision.
Important work.
Very. And his job specifically involved setting up software and hardware systems for those folks.
Tech support, basically.
Yeah, kind of. And this often meant he had to travel for work.
So he's out and about helping people access technology.
Exactly. Now, on one of these work trips, he had a bit of a run-in with a hotel proprietor.
Uh-oh.
Yeah, there were accusations of aggressive behavior.
A confrontation.
Yeah. And as you can imagine, both sides had different stories about what happened.
The classic he said, she said.
Exactly. So Vision Australia decided to take the hotel proprietor's side and started disciplinary action against Mr. Elisha.
And this is where things went wrong.
This is where it gets interesting. The whole process was later found to be flawed, really flawed.
How so?
Well, the primary judge, Justice O'Meara, didn't hold back. He called the disciplinary process a sham and a disgrace.
Wow. Strong words.
Yeah, so what exactly did they do wrong? Well, they didn't follow their own procedures.
You mean they had rules in place but didn't follow them?
Exactly. They had this thing called the 2015 disciplinary procedure, and they just ignored it.
Specifically?
They didn't give Mr. Elisha a letter outlining the allegations against him before the disciplinary meeting.
Seems like a pretty clear breach of contract.
That's what Mr. Elisha argued, and the initial court ruling agreed with him.
So what happened?
Justice O'Meara awarded him damages for breach of contract.
Which included?
Damages for psychiatric injury. It turns out Mr. Elisha was diagnosed with major depressive disorder after his dismissal.
That makes sense. Losing your job like that could be incredibly stressful.
Absolutely. But, as you know, this case went all the way to the High Court, so it wasn't over just yet.
What happened at the next level?
Vision Australia appealed the decision, and the Court of Appeal actually overturned Justice O'Meara's ruling.
Really? Why?
They cited a very old legal principle called the Addis v. Gramophone Code Ltd. rule.
Addis v. Gramophone?
Yeah, from 1909.
Wow, that's going back a bit.
It is, and this rule basically said that you can't get damages for psychiatric injury from a breach of contract during dismissal unless there's also physical injury. Or the contract was specifically for enjoyment or relaxation.
Which obviously wouldn't apply here.
Right. So Mr. Elisha decided to fight back. He appealed to the High Court. Barristers Perry Hertzfeld, Eitan Mikowski, and Stephen Puddick representing him.
And on the other side,
Vision Australia had Lee Howard and Michael O'Grady.
A real legal dream team showdown.
It was, and the judges presiding over the case were Chief Justice Gagler and Justices Gordon, Edelman, Gleeson, and Beach-Jones.
Okay, so the stage is set. What did the High Court decide?
Well, they overturned the Court of Appeal's decision.
So they sided with Mr. Elisha.
They did. They found that Vision Australia had breached its contract with him by not following their own disciplinary procedure.
And what about the old Addis rule?
They decided to do away with it.
Really?
Yeah, they recognized that it was outdated and didn't reflect the realities of the modern workplace.
Huge.
It was a big decision. So basically, the High Court said that Mr. Elisha suffered psychological harm because his employer didn't follow their own rules.
That's pretty groundbreaking. But how did they actually connect the disciplinary process to the other conditions clause in his contract?
That's where the details get really interesting. The High Court focused on a clause in Mr. Elisha's contract, the other conditions clause.
From way back in 2006, right?
Yep. And this clause basically said his employment was subject to Vision Australia's policies and procedures.
Standard stuff?
You'd think so, but the court determined that this clause wasn't just some vague statement. It actually created a legally binding obligation for Vision Australia to follow those procedures.
Ah, so it's not just a suggestion, it's the law.
Precisely. And Vision Australia tried to argue that policies can change over time, so they shouldn't be held to this specific 2015 procedure.
I can see their point. Things do change in a workplace.
They do, but the High Court wasn't buying it. They emphasized the importance of clear and consistent contract language. Basically, you put it in the contract, you're bound by it.
No wiggle room there. So essentially, even though it wasn't explicitly spelled out, agreeing to those company policies in a contract means you're bound to follow them.
Exactly, especially during something as critical as a disciplinary process.
Makes sense. Now, this is where Tim Donaghy's analysis comes in, right? He really dives into the legal details of this case and what it means for Australian employment law.
He does. Donaghy's paper offers some really valuable insights into the Elisha case and its broader implications. One of the key things he points out is that this case highlights the interplay between the Fair Work Act and general contract law.
Okay, two different sets of laws at work here.
Right. The Fair Work Act specifically deals with things like unfair dismissal and workplace relations.
So that's where you'd normally go for something like this.
Usually, yes. But the Elisha case shows that employees can also rely on good old-fashioned contract law, especially when their employer's actions have caused psychological harm.
So it's like an extra layer of protection. If the Fair Work Act doesn't quite cover it, you might still have a case under contract law.
Exactly. And Donaghy argues that the Elisha case sets a precedent for these kinds of claims. It's not just about the breach of contract itself, but also about recognizing the real and lasting impact a mishandled dismissal can have on employees' mental well-being.
The court is basically saying employers can't just treat their employees like disposable assets.
Right. They have a responsibility to act fairly and with a certain level of care, especially when it comes to serious things like disciplinary actions.
Now, Donaghy also mentions this idea of foreseeability that courts might consider in future cases.
Yeah, that's a crucial point.
Can you explain what he means by that?
Sure. Basically, it means the courts are going to ask whether an employer could have reasonably foreseen that their actions, especially a breach of contract, would lead to psychological injury for the employee.
So was it predictable that their actions would cause harm?
Exactly. And the Elisha case sets a pretty high bar for what constitutes such a breach. Remember, the judge called the disciplinary process a sham and a disgrace. This wasn't just a minor slip-up, it was a blatant disregard for their own policies, and it had very serious consequences for Mr. Elisha's mental health.
So if an employer just throws their own procedures out the window and treats an employee unfairly, it's not a huge leap to say that psychological harm could be a foreseeable outcome.
Exactly, and there's something employers need to be very aware of.
Okay, so back to Donaghy's analysis. What are the practical implications of all this for both employers and employees?
Well, for employers, it's a wake-up call. They need to take a close look at their disciplinary procedures and ask themselves some tough questions.
Like, are they clear? Are they fair?
Exactly. And do they include safeguards to protect employees from psychological harm? If not, they could be leaving themselves open to legal action.
It's not just about avoiding lawsuits, though. It's about creating a workplace culture where employers feel respected, valued, and safe.
Absolutely. And for employees, the Elisha case is a reminder that they have rights. They don't have to just accept unfair or harmful treatment. They can take action if their employer's actions have caused them psychological distress.
So it's a win for employees, but also a bit of a warning for employers.
You could say that. The Elisha case has definitely shifted the balance in favor of employees, and it's highlighted the importance of psychological well-being in the workplace.
Okay, let's bring this all home. What does it all mean for the average worker in Australia?
It means a few things. First, your employer is now held to a higher standard when it comes to your psychological well-being, especially during disciplinary processes.
So if you're facing disciplinary action at work, you need to be aware of your company's policies and procedures and make sure they're being followed to the letter.
Absolutely. Second, if you've been unfairly dismissed or if you've gone through a disciplinary process that's caused you psychological harm, you have stronger grounds than ever to seek compensation.
Don't just suffer in silence.
Right. Know your rights and seek help if you need it. And finally, this case has sent a strong message to employers across Australia. Create a workplace culture that prioritizes fairness, transparency, and empathy.
That's the takeaway. It's a win for employees, a wake-up call for employers, and hopefully a step towards more positive and humane workplaces for everyone.
I agree.
Okay, so we've covered a lot of ground. Unpacked the Elisha case, looked at Tim Donaghy's analysis, and talked about what this all means for you guys listening.
Yeah, a lot to take in.
It is, but before we wrap up, what can our listeners actually do with this information?
Good question. Knowing about this is one thing, but putting it into action is key. The first thing is to really get familiar with your workplace's policies.
Okay, get the handbook out.
Exactly, especially anything about disciplinary procedures.
Don't wait till something's happening to try and figure it all out.
Right, no, way better to be prepared so you know what your rights are ahead of time.
Makes sense. Read the instructions before trying to build that IKEA bookshelf.
Exactly. Look for the steps involved in a disciplinary process, reasons for dismissal, any support they offer.
And if something seems off,
Don't hesitate to ask. HR, a supervisor, someone you trust. Better to be safe than sorry.
definitely. Now, the Elisha case shows that employees do have some strong tools to use now, right?
Absolutely. Things have shifted. Your mental well-being is a big factor now, especially during disciplinary stuff.
Employers have to consider that.
They do. So practically speaking, what can employees do? Well, first, make sure your employer is sticking to their own procedures.
Okay, hold them accountable.
Right, and document everything. Meetings, emails, anything related to the process.
Build that case file just in case.
Exactly. Now, even if the procedures are being followed, it can still be super stressful to go through this.
No kidding.
Remember, you don't have to go through this alone. Talk to family, friends, or a therapist, anyone you trust.
There are also things like employee assistance programs, EAPs they're called, trade unions, or even legal aid services.
Right, good point. Lots of resources out there to help. It's easy to feel powerless, but you have rights. You deserve to be treated fairly.
Absolutely. The Elisha case set a precedent, but it's on each of us to know our rights and stand up for ourselves at work.
Well said. The law can be a powerful tool for change, but we all have a part to play in making those changes happen in the real world.
So a call to action for everyone listening. The Elisha case is a win for employees, but it's a reminder to stay informed and be proactive. Protect your rights, protect your well-being at work.
Agreed. It's about making sure those legal wins turn into real improvements in how we work and how we treat each other.
Let's turn this victory into a lasting change where everyone feels respected, valued, and supported.
Couldn't have said it better myself.
And remember, everyone, we've just scratched the surface here.
We have. There's a lot more to this case. We encourage you to check out the full judgment, read Tim Donaghy's paper, and keep learning about your rights.
We'll link to all that in the show notes. Thanks for joining us on this deep dive, everyone. Until next time, stay curious, stay informed, and stay empowered.